Companies Act, Section 218, Protection of Employees During Investigations. Section 218 of the Companies Act, 2013 is designed to protect employees of companies, other bodies, corporate, or individuals during investigations that concern the management and affairs of the company. This provision ensures that employees are not unfairly treated or subjected to adverse actions while an investigation or legal proceeding is underway. The section imposes procedural requirements and protections on employers when contemplating actions such as suspensions, terminations, or changes in the terms of employment for employees who may be involved in or affected by an ongoing investigation. The section outlines the approval process that must be followed before taking disciplinary or employment-related actions against employees during the investigation period, ensuring that these actions are reviewed and authorized by the relevant legal authorities. 1. Restrictions on employee actions during investigation. Subsection 1 provides specific protections to employees when an investigation is underway. It applies to investigations or legal proceedings concerning the affairs and other matters related to a company or body corporate, as prescribed under Sections 210, 212, 213, or 219. The membership and other matters relating to a company, or the ownership of shares and debentures in a company. Investigations under Section 216, concerning the ownership of shares in or debentures of a company or body corporate, or the affairs of a company or body corporate. During the course of these investigations or proceedings, if a company or body corporate intends to take certain actions against an employee, they must first obtain approval from the tribunal. These actions include discharge or suspension of the employee, punitive actions, such as dismissal, removal, reduction in rank, or other forms of punishment. Changes to the terms of employment that would be disadvantageous to the employee. This requirement ensures that the company's actions against the employee are not arbitrary and are subjected to judicial review, preventing retaliatory or unjust treatment of employees during investigations. 2. Approval process and waiting period. Subsection 2 outlines the procedural requirements for obtaining the tribunal's approval. It states that if a company, other body corporate, or individual intends to take any of the actions mentioned in subsection 1 against an employee, they must first apply to the tribunal for approval of their proposed action. If the company or body corporate does not receive the tribunal's approval within 30 days of submitting the application, only then can the company proceed with the proposed action against the employee. This provision establishes a clear time frame during which the tribunal has the opportunity to review the proposed actions and offer objections if necessary. It prevents employers from prematurely acting against an employee before the legal authorities have had a chance to intervene or approve the decision. 3. Right to appeal against objection. Subsection 3 provides the company or body corporate with the right to appeal if they are dissatisfied with the objection raised by the tribunal regarding their proposed action. If the tribunal objects to the proposed action, the company or individual concerned may appeal to the appellate tribunal. The appeal must be made within 30 days from the date the notice of objection is received. The appeal must follow the prescribed process, including the payment of any necessary fees. This right of appeal ensures that the company or body corporate has an opportunity to challenge the tribunal's objection and seek a different outcome if they believe the objection is unjustified. It introduces an additional layer of legal recourse for the company, ensuring fairness in the decision-making process. 4. Finality of appellate tribunal's decision. Subsection 4 establishes that the decision made by the appellate tribunal is final and binding on both the tribunal and the company or body corporate involved. Once the appellate tribunal has made its ruling on the appeal, there is no further legal recourse, and both parties must accept the decision. This provision ensures that once the appellate process has been completed, the matter is conclusively settled, offering certainty to both the company and the employee regarding the final decision. 5. Application of other laws. Subsection 5 provides clarity regarding the relationship between the provisions of this section and other laws in force. It explicitly states that the provisions of Section 218 shall apply without prejudice to the provisions of any other law for the time being in force. This means that while Section 218 provides specific protection to employees during investigations, it does not override or replace any other legal protections or requirements that may be in place under other laws. Therefore, if another law provides additional or stricter protections for employees in the same context, those provisions will still apply. For more details, contact us.